We do this. All right, so we have this morning Amy Wan with Bootstrap Legal. Amy is the founder and CEO of Bootstrap Legal, which combines AI and attorney services to automate real estate syndication legal documents. She was previously general counsel at a real estate crowdfunding platform. She was named one of 10 women to watch in legal technology by the American Bar Association Journal in 2014. And one of 18 millennials changing legal tech by law.com in 2018. So Amy, wow, you have a lot going on there. So that's pretty impressive credentials. I love the use of technology and automation and AI and everything that we do. It's very underutilized, especially in the multifamily field. So I'm looking forward to hearing what you have for us this morning. And just to give you a kind of our process, I'll have the question and answer box up. I don't know if you can see that or have that pulled up. If you look down in the bottom corner, or the bottom when you pull the toolbar up, it says Q&A and chat. So I have those up as well, and I'll kind of be monitoring the Q&A box. And it's however you want to do it, but typically we save the questions till the end and leave you about 15 minutes to answer questions, if that sounds okay with you.
Yeah, that sounds perfect.
And you have the time slot from 9:30 to 10:45, so I'll usually come in around 10 o'clock and go like that, but I'll be here. I'm going to shut off my camera and everything, let you have it, but I'll be here if we have any issues. So.
Fantastic. Awesome. Thanks so much. So I get to just take it away?
Yep, you got it. I'm going to jump off.
All right, sounds good. So hi, everybody. My name is Amy Wan, and I do a number of different things. But, first and foremost, I am a real estate syndication attorney. But I know that there are other attorneys over the course of these several days that are going to be talking about securities laws and all that kind of stuff. And, I think I've given the speech about, what are the regulations? What is the Howey test? So many times that I've pretty much memorized it. So I wanted to do something a little bit different today and address, from a legal perspective, some of the practical realities that a lot of multifamily syndicators often end up facing when they are doing a syndication, and stuff that has just, especially in the past couple weeks, that's come up for some of my clients, and stuff that I just think, real estate syndicators really should know if they don't already, right? So the first thing is, so the first thing is, yes, when you hire a real estate syndication attorney, it is about the documents, but it's also not really, right? I think a lot of times clients think, okay, I'm just hiring the attorney so they can draft me documents and then I go on with my day. That's really what I need the attorney for. Can you switch? Sorry, one second. Can you switch to full screen on your presentation? Okay, hold on. I'm getting a request to switch to full screen. Let me see. Sorry, I'm actually I have notes on my computer as well, so let's see if this works. Okay, sorry. Sorry, I'm just trying to do it so that my PowerPoint presentation doesn't take up my entire screen. Okay, let's see if this works. Yeah, I knew this would happen. Are you guys okay with this? It would be easier for me. There's a lot of stuff I kind of just want to go over. Okay.
Yeah, no worries. I just some people just forget to turn it on full screen, so I was just saying that. But no, I totally get it, that you have notes up there, so it's no problem. So no,
Okay.
Sorry, didn't mean to interrupt.
Okay, no worries. Okay, all right. So basically, number one is, a lot of people when they when they hire a real estate syndication attorney, they think, oh, I'm really going to this attorney to get documents. And yes, the legal documents are the deliverable that you actually get, but what I think is the most valuable thing about hiring an attorney is you are going and really hiring them for their counseling, right? The ability to call them up, to text them, ask them random questions. Oh, you're about to go tweet this deal. Maybe I should, run this by my attorney real quick and see if my marketing language is okay, right? It's about structuring, and I'll get to structuring in a bit. And that's not just like, oh, should I do LLCs? Should I do a GP-LP structure? Is this a JV? How many LLCs do I need? But it's also about the structuring of the deal itself with a lot of the financial implications. It's also about networking, right? Oftentimes, especially for my more beginning syndicators, they're coming into this for maybe the first or second or third time. They may have been trying to build up a network of investors, but there's still more people that you need other than investors, right? And so often, just because of the nature of our position, real estate syndication attorneys can help connect you with a wide variety of folks, people who are experts with tax, SDIRAs, 1031 exchanges. I recently connected one of my clients to someone on the financial side, CPAs. One of my other clients, wanted to know who were some good options for coaching, so I gave them a list. Or, when it comes to raising money, if your network is not enough, I have a client that started 3 years ago. His raises were much smaller then. Now his raises are like in the 10 million range. And so he's getting to that point where he's now drawing on some of the resources I connected him with, some 3 years ago, to syndicators who have been around for a while and have a whole slew of, investor lists that have been very historical. So basically all of this is to say it's so much more than just the documents. Sure, the documents are good. The documents are the deliverable, but really what you're looking for is someone with a lot of experience and has seen a lot of different things and has a wide network. So I promise number one is the most boring one. So number two, oh gosh, here we go, is, a lot of times people ask me, well, what are the different fees I can charge, right? And so at one point, a couple years ago, I went and wrote a whole white paper about what are all the different fees. And look, there is an infinite number of these fees. I literally have had people make up fees as well. It's not very common. That's more of a rare thing, but sometimes it is justifiable. So for example, I have one client who does new construction, and because their background expertise is construction management, they don't need to hire a construction management company. They can actually oversee the entire thing themselves, right? But they want to get compensated for that additional job. Whereas, someone else would normally hire someone. And so they came up with a construction management fee. I had one client a couple years ago who came up with a licensing fee, right? And that's because he had particular expertise in his local jurisdiction for being able to quickly obtain, or more quickly obtain, licensing that was needed for the project, and licensing that was typically pretty difficult to get. Oftentimes, to get that particular license, people would have to go and hire someone else. So he wanted to be compensated for it, and he had to disclose it. However, all of that aside, you should not, just make up fees. So I went through a lot of old documents and came up with what are probably the top 10 most common fees. Now, I will say you should not charge all of these. If you do, I think you're probably going to scare your investors away, right? But charging some of these fees is not only fine. I think it's very normal. So let's go through some of these really quickly. So the first one is the organization and due diligence fee. Some people call this the acquisition fee. And it's typically a one-time fee on the purchase of a property or of each property if this is a multi-property portfolio. Normally, I see acquisition fees in the range of 1 to 3% of the purchase price of the property. The vast majority of the time, it would be 2%. The sponsor usually earns this fee at the close of escrow on the acquisition of at the close of acquisition. Or the close of escrow of the property. And this fee basically is to compensate the sponsor for their efforts in conducting due diligence on the property and for making the investment opportunity available for investors. So the second one is the asset management fee. This one is also very popular, very widely used. It basically compensates the sponsor for their efforts in oversight and management of the company and property during the course of the investment. Typically, sponsors would charge like a 1 to 2% asset management fee based off the gross revenue collected from the property. And usually this is a fee that's earned monthly. The third one, so the third one is the property management fee, and oftentimes this is not to the sponsor themselves. They will go and hire a third-party property management company, and so we're just disclosing that this is how much we're paying for property management, albeit to someone else, right? Although it can be to the manager, it just usually depends on whether the manager is geographically close enough to actually do the property management. So this fee is basically collected during property operations and capital improvements. And we usually just say that the amount is commensurate with local rates for those types of services because, the fees in every state will be very different, right? The fourth one is the debt placement fee. Now, this one is not as common, but basically the debt placement fee is to compensate the sponsor for helping to obtain acquisition or purchase financing on the property. Because, getting a loan is a lot of work. Sometimes you have a broker, sometimes you don't. You have to go through a lot of different paperwork, things of that sort, right? So this is usually a one-time fee, usually something like 1% of the original purchase price of the property. And the sponsors that do charge this basically earn the fee upon the initial financing of the property. Next one is the loan guarantee fee. So this is different, right? The fourth one that I talked about, debt placement fee, is compensation you get for going out and doing all the work of getting a loan. The loan guarantee fee is if you end up having a loan that requires some sort of personal guarantee, people want to be compensated for that. Sometimes the sponsor is not in a position or doesn't want to personally guarantee the loan. So they might go to someone else to personally guarantee the loan and bring them in on the deal, right? In which case, that person is taking on a certain level of risk, and they should be compensated for it. So the loan guarantee fee is usually a one-time fee. It ranges between 1 to 3% of the loan. In the vast majority of cases, it's usually something like 2 to 2.5%, and it's earned when the loan is made. What I will say is for folks who charge a fee around the subject matter of a loan, I usually do not see both a debt placement fee and a loan guarantee fee. Again, we don't want to charge fees into oblivion and turn off investors that way, right? Number 6 is also slightly different. It's the refinance fee. So whereas the two that I just mentioned are charged, towards the beginning of the deal, number 6, the refinance fee is charged towards the end of the deal, right? So basically, under this one, the sponsor may earn a refinance fee as compensation for their efforts in obtaining refinancing of the property. This is also a one-time fee. It's usually 0.5% to 1% of the new loan amount, and it is earned on the origination date of the new loan. Number 7, and I'm going to try and go through these more quickly because I realize we are low on time. There's a lot to get through today. So number 7 is the disposition fee. So a disposition fee is a one-time fee that compensates the sponsor for their efforts in marketing the property or properties, if it's a multi-property portfolio, for sale. It's usually 1% to 3% of the sale price of the property, and it's earned upon the sale of the property, right? So I don't know, if it's single family, it might be staging. If it's multifamily or some other type, it's basically everything you have to do leading up to actually getting the property sold. Real estate commissions. So if you are a licensed real estate broker or salesperson, and you have thought before about taking commission off the acquisition or the sale of the properties that you also want to syndicate, that's perfectly fine. You just have to disclose this to investors, right? The commission should be commensurate with local real estate commission rates. Now, if you are not a licensed real estate broker or salesperson in your state, unfortunately, this is a fee that you cannot take. This is only for those who have this type of licensure. Number 9 is a pretty intuitive one. It's just expense reimbursements. You've probably, when you're getting ready to go do a syndication, you've probably put some of your own money into the deal before even raising a dime, right? That is traveling to the property, due diligence, things of that sort. So, forming the entities, right? And so you can get your out-of-pocket expenses reimbursed on startup of the company and thereafter. And certainly, last but not least, there's the interest on deferred fees and manager advances. So before we get into this one, I want to say that sometimes, especially for beginning syndicators, they don't realize that they can charge interest whenever they defer, for example, their own fees or reimbursements for expenses that are owed to them. Usually we set that interest rate at 10%, but it can be whatever. Sorry, it can't be whatever you want. Most of the time, people will set it lower. Sometimes beginning syndicators will even not charge an interest rate because they're afraid of scaring away investors. So that's something that you can do. And I wouldn't be afraid of doing this because this is pretty standard practice, right? Honestly, just sometimes the sponsor has to defer fees because of certain situations, right? Maybe they only raise the minimum amount or something like that. So whenever stuff like that happens, they can basically collect interest on the deferred fees, the manager advances, the unreimbursed expenses that are not paid, despite them being due at a certain period. And then, oftentimes, if fees are deferred, you want to pay them off as quickly as possible, right? Because, investors don't want to pay you that 10% or whatever it is you're charging. But at the same time, if you're not able to, then you certainly must do it prior to distribution to investors. So, again, what I'll say is all these fees are very standard. Don't charge all 10 of these. Otherwise, you are certainly going to have a very difficult time explaining that to your investors. So number 3 is cash distribution structures. So when I wrote the white paper on the top 10 fees, I also ended up doing a lot of research through old documents and coming up with what are the most popular distribution structures to investors. And it really just comes in one of three flavors. And obviously there's different types and options that we can do to make things more fancy. But of the three most popular types, the first one is just pro rata, right? We call this a standard split. So pro rata is basically a fancy Latin word that means proportional. So under the pro rata distribution model, distributable cash is given to investors proportionally according to their membership interests. When it comes to splits, I would say probably the median distribution between investors and sponsors is something like a 70-30 split. So what that means is 70% to investors, pro rata, and then 30% to the sponsor. There's usually like a 10% standard deviation. So I've seen as a range from like 60-40 to 80-20, although I would say 70-30 splits and 80-20 splits are probably the most common. The second type is the preferred return followed by the split, right? So some of you guys will call preferred return a pref, but it's basically a distribution preference to investors where distributable cash is, when it's distributed, is first given to certain members, again, the investor members, until they achieve a certain rate of return or on their initial investment, right? Usually this will be something like 8%, 9%, although it varies by deal, right? In multifamily, I usually see 8 to 9%. But, for new construction, where there's more risk, that can go higher. And it may also depend on geography, right? When you are using a preferred return, you should be careful to specify whether or not it's cumulative and how often it's compounded. Now, when we offer a preferred return followed by a split, basically what happens is we give, for example, the investors that 8 to 9%, and thereafter, with the remaining distributable cash, it'll be, if we're doing a 70-30 split, it's just of the remaining cash, we just distribute it. The rest is basically pro rata, right? So of the remaining cash, 70% goes here, 30% goes here. Now, I want to contrast this with number 3, which is the preferred return, which is included in the split. And some of you guys call this catch-up provisions. So basically in this scenario, after investor members receive their preferred return, the investor members then get a percentage of the distributable cash pro rata, and the sponsor receives a percentage of the remaining percentage of the distributable cash. Now, the difference is that the preferred return is actually included in the calculation of the catch-up or the split, right? So I want to give you an example of how the two are really different. Let's say under number 2, the preferred return followed by the split, you have $100, and maybe it's a 10%. Let's make the numbers easy. Maybe it's a 10% preferred return, and 50-50 split, right? So $10 would first go to investor members. Then you have $90 left. If that's being split 50-50, then it's 45-45. So that means at the end of the day, the investors would have gotten $10 plus $45, so $55, and the sponsor would have gotten, 45, right? Now contrast that with the preferred, number 3, the preferred return included in the split, with the same numbers, 10% preferred return, 50-50 split. We're first going to pay investors $10, right? And then we don't look at the remaining distributable cash when we do the 50-50 split. We have this catch-up provision So once investors receive their 10% preferred returns, their $10, then it's split 50-50, but the preferred return is actually included with the remaining distributable cash. So at the end of the day, investors and sponsors are basically going to end up with $50 and $50 respectively. So when you are structuring your distributable cash, there are other things that you might want to take into account, right? So one of those is frequency of distribution. How often are you going to be doing your distributions? And really there's, although you can do whatever you want, there's three main models. One is annually, one is quarterly, one is monthly. I always try to push my clients to do this quarterly because it's not so frequent or so often that it kind of becomes a pain every month. But at the same time, annually tends to do distributions annually tends to not be often enough, right? Your investors don't only want to hear from you once a year, but at the same time, the frequency of distribution can be a nice thing that works for sponsors, because the more frequently you do your distributions, A, the more happier investors are, but B, when you're doing your next syndication, oftentimes, it can be a nice thing. You pay a distribution on a previous deal, and you say, oh, hey, by the way, and this is why the investor is all good and happy because they just got their distribution. Hey, I'm having another syndication. Do you want to invest in this one as well, right? So it's a nice excuse to A, make them happy, and then B, have an excuse to talk to them on a semi-frequent basis. With distribution structures, there are also reinvestment options. Now, I will say that reinvestment options are not popular, but they're not rare. And you only want to use them in certain types of deals. But so let's say, for example, you have a multifamily deal and we've said, hey, we expect that we're going to hold this apartment building for 4 to 7 years, which is what's standard, right? Let's say that the sponsor team, when they're setting up the syndication, knows that there is a possibility that they could just flip the building very quickly, sometime in the first 3 years. Well, then that capital isn't outstanding for investors nearly as long as investors would have anticipated. And so these sponsors will write into the deal, hey, we want to have a reinvestment option if, for some reason, we are able to sell the apartment building for a good number within the first 3 years or 36 months, then we have the right to basically take that capital and go and reinvest it. Now, this is something you definitely need to explain to your investors, right? Some investors will like this and some investors won't. Remember that when it comes to your real estate syndication, investors are really evaluating two things. One is the sponsor or the sponsoring team, and two is the property, to the extent it is a single asset syndication, right? And so they might not like that, although they know you, the sponsoring team, they might not like the fact that you can go, in your sole discretion, go and take that capital and go reinvest it in another property, sight unseen, without them having approved. So this really works for a specific type of sponsor, usually one where they've been operating for a little longer and their investors really trust them. And the last thing I wanted to cover for this is multiple waterfalls. So occasionally I will get clients who, maybe after the preferred return and a split, they will set up, multiple waterfalls where it's something like, hey, and then once investors achieve a 13% IRR, thereafter, it's a 60-40 split. And then once they achieve a 25% IRR, then it's a 50-50 split. So the nice thing about multiple waterfalls is that, you know, it's a structure that really incentivizes the sponsor to go and make the investors as much money as possible. The downside is that if you have investors that are not that sophisticated, this may be confusing to them. So that brings me to my next point, which is keep it simple, right? I'm not gonna say the last word, but sometimes I get folks who come in and they've set up these really elaborate distribution structures with multiple waterfalls and all of these things. And oh, but if this happens, then we're going to do this. But if this happens, we're going to do this, and we're going to have a repurchase option and all these fancy things. And even if it's not on the distribution structure itself, it's embedded into the deal, right? Oh, if you invest within this amount of time, you'll get this. But if you invest within this amount of time, you'll get this. What I'll say about that is, you know, at the end of the day, you can set these things up whatever you want, although of course you always have to keep the numbers in mind. But we don't want to overwhelm or confuse investors. And if you cannot explain to investors in one or a couple breaths exactly how this deal works, I think that's problematic. You have to remember that, you know, even though, you know, and I'm sure the other attorneys are going to talk about accredited investors, non-accredited investors, right? To the extent you have a non-accredited investor, this may be very confusing for them. I will also say that as someone who has had to verify the accredited status of many, many investors before under Rule 506C, you would be very surprised. Not all accredited investors are sophisticated. Some of them have trust funds. Some of them, I don't know, got lucky, right? And so we do want to try to keep deals as simple and straightforward as possible. Otherwise, things just get really, really confusing. All right, next slide. Did I skip something? Okay. All right. Let's talk about capital raisers. I know this is a topic that a lot of people run into. It's a topic that I don't really like to talk to people about publicly because you have to be very careful about what you say. But I know it's a reality for a lot of you, right? So I want you guys to finish the sentence for me. If it walks like a duck and it quacks like a duck, it must be the answer would be duck. When you talk about capital raising, I see a lot of you are replying duck now. So when we're talking about capital raising, right, it is, it's one of those things where you kind of have to conduct a smell test or a sniff test. A capital raiser is someone who is compensated, whether in the form of equity of the management company or equity in the deal or just straight up commissions or something like that. A capital raiser is someone who gets what we called in legalese transaction-based compensation, right? So what that means is their compensation is dependent on a transaction actually happening. So if they do not go out and raise any money, they don't get anything. But if they go and raise a ton of money for you, they are compensated accordingly. You cannot do this, and you cannot work with these people unless they are licensed with FINRA as a registered broker-dealer. Only registered broker-dealers are allowed to charge commission or what we call transaction-based compensation. Now, I know that there are a lot of folks out there who do help sponsor teams go and raise capital and they are not licensed as broker-dealers. And some of them are doing it legally. Some of them are doing it illegally, right? So there's usually 3 ways that this works. And the third way is probably the most common way that I've seen. But let's just go through this very quickly. So the first is they have some sort of alternative agreement. And that they might call it a marketing agreement. They might call it a consulting agreement, right? Call it whatever you want. It doesn't matter what you call it. It just matters, again, whether it walks like a duck and quacks like a duck. You cannot compensate them for them bringing money to the deal, again, unless they're licensed. You can compensate them for helping you put together an investor deck, for helping you come up with a marketing strategy, for helping you on the deal itself. But it cannot be transaction-based compensation. It cannot be tied to however much they're raising for you, right? And, you know, for all 3 of these that I'm going to talk about, when I explain this to syndicators, I get a lot of questions of, oh, but what if we do this, right? What if we do this? And they're all just trying to find loopholes and dance around what the rule really is. But the rule is very, very simple. So I would urge all of you guys to use your common sense when it comes to this stuff. The second way is to create a fund of funds. So what a fund of funds is basically the capital raiser they might go find a deal that they really like. Now, because they can't charge transaction-based compensation, instead of going and funneling people directly into the parent syndication, they will start their own syndication, right? They'll raise their own fund. We call this a fund of funds. So they raise money from their own investors, and then they take that and then they go invest it in the parent syndication. That's okay. However, there are a number of things that you have to consider if this is something that you're doing or something that the capital raiser that you're working with is doing, right? So the first one is that because now suddenly there are 2 syndications and not 1, you're going to be faced with higher transactional costs because guess what? Now you need 2 PPMs and 2 sets of operating agreements and 2 of everything, right? Because technically it's a different offering. So for folks who are doing fund-to-fund models, it does tend to be for larger raises, larger deals where there is enough margin or room in the deal to be able to pull this off. You're definitely not going to do this for tiny, $1 million parent syndications. The second thing is, basically when you are doing, a parent syndication or a regular syndication itself, the syndication is selling a security, right? You're raising capital to basically go and invest that in real estate. You are not investing it in another security, but that's what a fund of funds does, right? You're raising capital to go invest in someone else's syndication, and they're selling security, and then they're investing it in real estate. So because you're now investing in a security and not real estate directly, you trigger a different set of regulations, and those are called registered investment advisor regulations. Basically, to be able to invest money for investors in other securities, you need to be a licensed RIA. Now, there's some good and some bad around this. It's always harder to be regulated, right? It does come with its own set of risks. There's a bunch of different regulations that you have to comply with. I think for most people in this audience, what you should know is there are 2 different levels of RIA licensing. One's at the federal level with the SEC, and one is at the state level. To get licensed at the federal level, I think most people in this group will not be doing that because you have to have a large amount of assets under management. I think off the top of my head, it's like 25 million or something like that. However, if you are doing less than that, then you register at the state level. Now, every state has different RIA laws, right? Some states say, hey, if you're only doing a one-off thing, or you're just, raising a little bit of capital, that's okay. We have an exemption for it. And every state's exemption is also different. Some states don't require you to do anything. Some states say, okay, we're not going to have you actually register as a California RIA, but you have to go fill out this form. And the form that they usually have you fill out is like an 80-page form. So it is quite intense, right? And that's just the beginning. After you fill out that form, then there's ongoing maintenance, right? And then there are some states that don't give you an exemption. So you end up having to register and go do the full gamut of registration. And that is more complicated than the 80-page form. So my point in all of this is basically to say that it is harder to do a fund of funds for many different reasons. And you have to be, I think, pretty sophisticated, and you really want to make this your full-time job, and do a lot bigger deals if you're going to do the fund of funds thing. And the third and most common way that I see capital raisers get involved with a deal is they actually become a part of the sponsor team, right? So usually it'll be like, okay, of the sponsor team, maybe there's 3 or 4 people involved, and maybe one or two of those folks are the main sponsor, and maybe there's 1 or 2 other people who just have a tiny part of the GP or the management group, maybe like 5% each or something like that. What I want to stress to you here is that, first of all, it's a couple of things. You as the syndicator cannot bring a capital raiser into the deal in a way where their only duty is to raise capital. They have to do other things other than raising capital in order for them to earn their part of their slice of the management or the GP, whatever you want to call it, right? So capital raising can be one of their many duties, but you really want them to have other duties. And if they are going to be helping you to raise capital, what I would do is document somewhere, what are the duties of everyone involved on the management team, right? This person's going to handle legal and interface with the CPA. This person is going to do capital raising, investor relations, and handle the property manager. This person's going to do this. You want to make sure that all their additional duties are documented in case one day you get audited by the SEC. The other thing I want to bring up is that, occasionally people send me interesting things by email to get my opinion on, and I've had some friends who have had folks go so far as to claim under certain obscure laws that they don't need to be a registered broker-dealer, but they can raise capital for people because they have this certain type of hedge fund. And, after doing a little bit of sleuthing, it comes down to, this is a question of interpretation, but most attorneys, and probably the SEC, would still say, no, you can't go and be raising capital and be compensated for it. Another thing I've seen recently is people are writing up agreements where they will let a capital raiser have a part of the GP, the management group, but there's an algorithm that calculates how much of the management group they will actually get. That's called transaction-based compensation. The person who sent this to me was trying to argue with me that it was not, but this is like the quintessential definition of transaction-based compensation, because if they don't raise anything, they don't get any part of the GP, right? And even if they have additional duties, it all comes down to how much they're raising. So if you come into one of these scenarios, I would probably urge you to go talk to your attorney. As a general rule of thumb, and I've been on this side of the equation too, I would say that if you talk to 20 different attorneys, you might end up getting 20 different answers, right? And that's the unfortunate nature of the situation when it comes to law. However, I do think that when it comes to laws around broker-dealer, laws around disclosures, which I'm going to talk about in a second, most attorneys should be on the same page. All right, and last but not least, disclosing previous life events. Now, I hope that this last topic does not apply to most of you, and I'm sure it doesn't apply to most of you, but you should still listen closely, because you may run into a situation where it does apply, not because of stuff that you've done, but because of stuff that maybe one of your business partners or other people on your sponsor team has done, right? And that is basically disclosing previous events. Now, in your PPM, you are obligated to disclose certain things, bankruptcies, whether for personal ones or for business, litigation, current and ongoing, previous orders or decrees from the SEC, for bad actor status. That's actually not something you would disclose, because if you have been named by the SEC or state regulator as bad actor, you just really can't be raising capital, period. There's a whole list of events that you might potentially have to disclose. Now, when someone does fall into one of these categories, for them, oftentimes it's a very embarrassing situation, right? And they don't want to disclose it. So I'm going to give you my non-legal opinion first, which is it's always better to be upfront with investors and disclose to them things that they might learn later on. Because if they learn it later on and it's not through you, there will be, I think, a breach of trust, right? And not only will they not trust you for future deals, those investors would be very, very nervous about deals they're already invested in. And the last thing you want to do is, have an investor sue you. It's not a great thing. When I explain the risk of disclosure or non-disclosure to clients, I basically tell folks that there's two things that you have to think about. Everyone automatically always thinks about the SEC. Oh, what if the SEC catches me, right? And that's what we call regulatory risk. And yes, the SEC can be a scary body, but what I say to clients is the even bigger risk is litigation risk. The SEC, if you cooperate with them, they might fine you, they might do another order or decree against you, or something like that, right? There might be civil, maybe criminal penalties depending on what you've done. But generally, if you hire a good defense attorney and you're very cooperative with them, I mean, these are government employees. They're just doing their job, right? There's not some sort of like emotional thing behind this. Contrast that with getting sued by your investors, and they go and they hire a bulldog attorney who has no incentive to cooperate with you. Their incentive is they're getting paid on contingency to milk as much money from you as humanly possible in getting to some sort of settlement or going through a jury trial, whatever. Litigation is it's long, it's expensive. The only people who win are the attorneys. No one ever likes paying attorney fees. don't put yourself in that situation, right? So what I really want to say say about this topic is that although for folks who have gone through bankruptcy or fall under one of these categories, although it may be embarrassing to disclose these previous life events, don't fight with your attorney on it. It's it's often not a decision that you can make. It's going to be the attorney's call, right? Because it's also their malpractice insurance that is on the line. Now, when it comes to how much you have to disclose and for how long you have to disclose it, there are a bunch of different rules and a lot of guidance from the SEC. But whatever the SEC says tends to be the bare minimum. And attorneys who are actually representing you in a deal, they're not going to do the bare minimum. The reason is because when it comes to disclosure of these events, you have to disclose whatever is material, right? You have to disclose, and by material, what I mean is if an investor thinks that that is pertinent or relevant information in going and making the investment, you have an obligation to disclose it. Sorry, I lost my train of thought for a second. It also depends on exactly what kind of deal you're doing. So for example, if you're doing like a 5-6C, you're working with only accredited investors who are all presumed to be very sophisticated, you might not have to disclose, a personal bankruptcy from 10 years ago. That might not be considered relevant. If you are working with even one non-accredited investors, you will want to disclose as much as humanly possible, right? If you do not disclose and the investor finds out later and they sue you, they technically have a right of rescission. And what that means is they have a right, basically forever, to ask for their money back plus interest. That's not really a situation you want to be in. So it's not a good thing. The last thing I want to emphasize about this topic is that although a lot of you may not have gone through bankruptcy or have, investors sue you for a previous deal or have anything that would be disclosable, that is not necessarily the case of your business partner, right? And if you end up sponsoring a deal with someone else where they either haven't told the group or they're trying to fight it and they don't want to disclose, this actually presents a huge risk to you because you haven't done anything in the past, but to the extent you don't disclose on that deal, investors can basically come back, see you in the future, and because you were part of the sponsoring or the management team, now on every future deal, you have to disclose that, on a previous deal, we didn't disclose this thing that someone else did, not something that you did that someone else did. So it's not a good thing. So I would always say, you want to over disclose. So I hope I haven't ended this whole presentation on kind of a Debbie Downer note, but this is actually something that one of my clients is going through right now. And I think emotionally it's very difficult for them because the thing that happened so long ago, according to them, wasn't even their fault. They had no control over the situation. So, always be careful who you're working with, and you never want to get into a situation, if you can help it, where, you have to think about these sorts of issues. All right, so I'm going to basically open it up to questions since we're about at the hour mark. So the first question is from Denise. What is the most common KISS distribution that you have encountered? So basically the 3 distribution structures that I went through earlier are the most common ones, right? And again, that's pro rata, that is preferred return followed by a split, and preferred return inclusive of a split. Again, preferred return in multifamily value add, we usually see like 8 to 9%. And the standard for the split will be anything from 70-30, 80-20. Okay. Josiah has a question. Amy, how would you recommend a GP structure their first syndication? Pro rata to not make it complicated. So, okay. So first of all, let me unpack this question a little bit. There's a lot of different aspects to structuring, right? Like, oh, what legal entity are we going to use? What state are we going to be in? Josiah mentioned a GP-LP structure, and that's actually different from an LLC structure. I usually recommend for folks who are just getting into this, and even for folks who have been doing this for a while, especially to the extent that they're not doing this full-time or they don't have a larger permanent team, they actually want to go with an LLC structure, not a GP-LP structure. Reason being is because LLC structures, from a management perspective, tend to be more flexible. And this is basically a succession question. The question is, if you and your sponsoring team or someone else from your sponsor team gets on an airplane and the airplane goes down, and I know this is not a pleasant thing to think about, but this is what we have to think about, right? What happens to all your investors? Who is going to manage the deal or the syndication for them now, right? And under an LLC structure, it's a lot more flexible, whereas under a GP-LP structure, it is a lot more rigid. I think the context of structuring in your question is what sort of cash distribution structure would you go with? And really, that's not a question that I can answer for you generally, because it comes down to two things. One is, what does the math say? Because you always have to run the numbers, right? You can't force a distribution structure on a deal that does not make sense. The second thing is, of the three that I outlined, all of those are perfectly fine, right? And I would say actually the latter two are the most popular. If I had to choose one, it would probably be the preferred return followed by the split, right? But any of the three structures that I mentioned earlier is completely fine. What I would not do, right, is something like a triple waterfall or, reinvestment options or something like that. Again, we want to keep it simple. Do we have other questions?
All right. Yeah, it looks like you answered everybody's questions on the way there. There's a lot of very valuable information. And please be sure, we have a couple minutes remaining to type your questions in the Q&A box. And Amy will be sure to answer those. So I was just kind of going back through some of your slides here. Setting up SEC regulations is, like you said, you go to 10 different attorneys, you get 10 different answers. You've seen variations on everything. You were talking about capital raisers and transaction fee compensation, and different viewpoints on that. And so it's very very interesting, and I always love learning new things. I'll never be a professional in this area, but you still have to understand it if you're going to be a syndicator. And it looks like we have another question. This says, you mentioned a white paper on top 10 fees. Where can they find that?
Good question, actually. I used to have it online and I took it down 2 years ago for some reason. But if you guys email me, I'm happy to shoot it over to you. I can type my email in this, in the chat. It's just amy@bootstraplegal.com. So if you email me and say, hey, I saw you on the summit this morning, can you send me, the papers? I'm happy to shoot it over to you. Just letting you know, it might be like a day or two before I can get back to you, because I'm in Brazil for a wedding right now.
Yes, and yeah, For those of you that weren't tuned in at the beginning, Amy is in Brazil. She had a run-in with yesterday. So have you ever seen the movie Bridesmaids? You know,
Oh
the
my gosh,
Brazilian
I
steakhouse.
have.
So,
I'm gonna say not nearly so bad, but yeah.
good. Sorry, I hate to
I,
conjure up those images in mind.
stay away
So
from Brazilian sushi.
that's true. What time is it there in Brazil?
It is, I think it's 11:30.
Oh, okay. All right. So you're only that's not too bad. Not too bad off of us. So, well, Amy, thank you so much for joining us. Do you want to tell our attendees more like how they can get in touch with you or follow up with you? You already posted your email, website, anything like that you want to put up for our
Yeah,
attendees?
sure. So my website is very simple. It's just bootstraplegal.com. We have a unique approach to real estate syndication law and legal, right? So I have a tech startup, and I've also been general counsel of a real estate syndication tech startup. And so basically, I was sitting there writing these documents over and over again manually, and I thought, my God, there's like got to be a better way. So caught on some tech expertise and sat there for one summer, basically parsing out the logic of all these things, and basically came up with what I call, TurboTax for real estate syndication. So it's basically software where you go in, you fill out a lot of the details of your deal, and on my side, we actually are able to automate the first draft. Thereafter, we basically do the regular back and forth attorney process. But because we are able to at least automate the first draft, I calculate that we probably cut off like 20 hours off of every deal, and we're able to turn around documents faster, and they're actually more precise than what a human being oftentimes would draft. So, we usually turn around the first draft of legal docs in 3 business days.
That's that's incredible. So anybody looking for those services to get faster closing, that's always a big thing when you're going to the table. The sellers always want to know who's going to close the quickest and the easiest. And so if you have attorneys on your side that can do it, that can cut 20 hours off, you want the seller, or you want to be waiting on the seller to provide documents. You're going to buy a deal. It just makes you look better to the brokers and everybody else moving forward. So, Amy, thanks again for being with us this morning. Hope everything works out well for you in Brazil. Good luck with the wedding, and thanks for joining us this morning.
All right, sounds good. Thanks so much, guys. Bye.
Bye. All right, everyone. Thanks again for joining us for that session. Let me just turn off our